I'm here with Ken Javerbaum of Javerbaum Workcraft. Hi, Ken. How are you?
Good seeing you, Warren.
Thank you for coming on my show. What do you think so far? You like the surroundings here?
I like the surroundings here, and the people who work here are terrific.
They are.
It's really nice. They're very friendly. It's great.
It's a podcast. What do you think about that?
I'm too old to really appreciate podcasts. Maybe it's going to get me started. I've listened to one or two. My grandsons have told me about it. But I like the whole idea. I could spend the rest of my life listening to podcasts.
Well, I'm glad you came here. We're honored and
Thank
privileged. I like to know a lot. I found you're our first guest, so I hope you're okay with that.
That's great.
And I know you have enormous successes in the legal profession, and we'll get to that all. But unfortunately for me, I always want to find out about what someone's background is around, because that dictates a lot. Sometimes it doesn't, but sometimes it does. So do you feel comfortable talking about how you grew up and your background as far as a young Ken Javerbaum?
Sure, it's one of my favorite things to talk about.
All right, sounds good. So where did you grow up? What town?
I grew up in Newark, and I grew up in a section of Newark called the Central Ward. Newark was divided in those days by ward numbers, and each ward more or less had a different ethnic majority. Where I grew up, it was not. It was all mixed.
Right.
And the South Ward, for example, in Newark was largely Jewish. The North Ward on the other side of town was largely Italian. The East Ward, before it became Portuguese and Spanish, which it is now, was largely Polish. But I lived in kind of a polyglot in the Central Ward, and consequently all my classmates were very, very mixed.
Did your parents immigrate here, or were they born here?
My parents were born here. My grandparents were not, but my parents were both born here.
Where were they from, grandparents?
My maternal grandparents and my paternal grandparents were both from Poland or Russia, but from what I understand, the lines were always shifting, so you never knew whether it was Poland or Russia.
Did they ever talk about their background to you, or are they just focused on making a living, putting food on the table, things like that?
Well, I had much more contact with my mother's parents than I did with my father's parents. My paternal grandmother died when I was only 4 or 5. By the way, parenthetically, she was born in Poland. Her maiden name was Lena Horn. Go figure.
Oh my God.
No relation. And my paternal grandfather was then in a nursing home after his wife died. And my father and I would go visit him pretty much every Sunday or every other Sunday. And he had a very peculiar occupation. He was an umbrella repairman. I never figured out how we made a living doing that. And my mother's parents, we'd see pretty much every weekend. My grandfather owned an appetizing store in the Lower East Side, now Alphabet City, on 10th Street in New York, between Avenue B and Avenue C. And I would go, from the time I was 11 or 12 years old, there wasn't the fear in the streets that there is now. I would go pretty much every weekend when I was 11 or 12, from my home in Newark to my grandmother's home at 153 Avenue B in New York. I'd take a bus to downtown Newark. I'd take the Hudson Tubes to 9th Street and 6th Avenue. I'd walk to 8th Street and 6th Avenue and take it to Tompkins Square Park at 10th Street and Avenue B. And everything was better in my grandmother's house. The Heinz ketchup tasted better. The Pepsi Cola tasted better. I had my own bedroom there as opposed to my house where I did not. I'd go to bingo with my grandmother on Saturday night because she couldn't go until it was sundown. She'd go to a church, and she could barely speak English, but she had like 12 bingo cards. I had 2, and I'd overlook something. She'd find it, but they were great memories. I'd just go to my grandmother's every weekend.
So did you have when did you know, I'm not going to ask you when did you know you would be a lawyer, that's a little cliche. When did you know that you wanted to do something like on a professional side? Or, I mean, usually I was like in 7th grade. We had career day, and they said, what are you going to do? So I wrote a book, I want to be a lawyer. So I knew earlier this is what I wanted to do. My motivations are, suspect or why I wanted to do it, but I definitely wanted to become a lawyer. When did you first know this is something that you wanted to be? What was your first exposure to law? I mean, because law, people that want to be lawyers, fascinated me why they want to become lawyers and when, at what age.
I never really had a burning desire to be a lawyer back in grammar school or even high school. I used to like lawyer shows. I watched Perry Mason,
Right.
I watched The Defenders and things like that. But I never really thought of being a lawyer. And what happened was, the summer after my first year of college,
Right.
I got a job carrying mail at the Newark Post Office, one of the branch offices. And I got the job because my father was a window clerk in a post office, and so I got a job carrying mail. So the way it works in a post office, if you're a mail carrier and in the summer you're substituting for other carriers or regular carriers, you get there 6 o'clock in the morning. You pitch the mail that on a route that you have. It's called
Right.
pitching the mail. And then you'd send some mail out to relay boxes where the trucks would take it. So when you ran out of your first bundle of mail, you pick up a second bundle of
Right.
mail. So the first day I did this, I had all my mail done by 8 o'clock. I went out to the route. I'd never seen it before. I was a rookie. And I came back about 10 o'clock. And the boss said, "What's the matter, kid? What's the problem?" I said, "I'm done." He said, "You're done?" He points to another guy there. He says, "Joe, talk to the kid." And this guy, Joe, is a wise, savvy guy. He's worked in a post office
Right.
forever. He knows all the answers. He says, "Kid," out of the side of his mouth, he says, "Kid, you're killing the job. You can't do this. What you're supposed to do is not just run the route.
Right.
You're supposed to take your time. You're supposed to stop at the sweet shop for something because you don't want the post office to audit you one day." So I just couldn't take my time doing that. It was tedious. And there was a trial going on in Newark that got a lot of publicity. 3 guys, I still remember the name of the case, State v. Russo, Bisignano, and LaPierre. And this was the summer of 1964. They had walked into a bar. An off-duty policeman saw them, and they shot him and killed him. And this is before there was a public defender's office. So each had a lawyer defending him.
Right.
And the prosecutor at that time was Brendan Byrne, who went on later to become governor. And I'd watch the trial. I'd have my little leather mail bag, and I'd just be sitting in the courtroom. Very often, just 2 or 3 of us sitting in the courtroom. And the judge would say, "Counsel, I'll see you in chambers." And then the counsel would line up, and this big brass door would open.
Right.
And I imagined like it was King Tut's tomb. It wasn't an office, it was chambers. I couldn't imagine what was there. But one lawyer was particularly good. He was a towering figure. He was very good. And I thought he was sensational. And I got interested in the law. And then ultimately, 3 years later, when I got out of law school, I followed his career. He was one of the great lawyers in New Jersey, very versatile. His name was Samuel Larner. Just as I was getting out of law school, he was appointed as a judge. And I wrote to him, contacted him, and got a judicial clerkship with him. And that's when I really got turned on to it in terms of going to law school, watching that trial in college, and then, wanting to do what those guys had done.
Did you, as a clerk, and I have always tell law students, get a clerkship. This is very important. But as a clerk, what is it that you start to learn about the profession that they didn't teach you in law school? Like, what are some of the day-to-day realities that you're like, whoa, I wish they taught this in law school? What sort of...
Well, I just want to go back on something
Sure.
you said. You said you always tell people to get a clerkship. I don't agree with that.
Okay.
Because I think there are different clerkships. There are some judges who have been at it so long, they know it all, they have no interest in mentoring somebody, and I think it's just a dull year and you could do other things for that year. But if you're really with a judge who knows what he or she is doing
Right.
and really cares about it and knows how to form a relationship
Right.
of mentoring and working with the clerk, then it's really a valuable kind of thing.
It's a valid point because I never had a clerkship.
Yeah.
No one really told me to do that. But what is it that you learned from, let's say you do have that hypothetical great mentor
Yeah.
type judge. What is it that you learn from a
Well-
judge and a clerk? Like what goes on?
Well, I'm watching trials every day.
Okay.
Some judges don't want their clerks in a courtroom, but this was a great experience. And he was just a very hard taskmaster because he had great expectations because, as good a lawyer as he was,
Right.
he was not tolerant of people who were less than him. And he was very demanding and very exacting in terms of my research and making sure it was right and accurate and shepherdizing cases, which means following up and getting them current. And I enjoyed watching the trials when they were in progress and then having him come back to the chambers and telling me more or less what they did that he thought was good, which was very few things,
Right.
and telling me what they did that was bad, that was really helpful, really helpful to me. And in those days, it wasn't where a judge was on civil or criminal or matrimonial. They would throw to a judge. There were not these departments. Whatever was next, you could see civil cases, criminal cases, and we had the Reuben Hurricane Carter case.
That's
which
a
was
fascinating case.
Great case, great exciting experience for me. But I was watching these lawyers try cases, and after a while I said to myself, I can do this. I mean, I can do this, I really, really can. And I just enjoyed talking with the judge on motion days and things like this. And I realize now,
Right.
he was only 58 years old when he became a judge. And he seemed so old to me. I guess I was 24, 25. And he was such a powerful guy in all respects. And it was just a great experience working for somebody who's demanding or exacting. And I think that's a much better experience than working for somebody who says everything's acceptable. I think
Right. Yeah.
I think you need somebody who's a good taskmaster.
I agree. Is there any particular style of a trial lawyer, for example? Watching different trial lawyers, I always find out, like, what is your personality, the authentic self? Usually they become good trial lawyers, people that are just, or they know the facts, they know the law, but there's a plus dimension to them. What makes someone a good trial lawyer? What styles do you like that particularly you adapted to?
Well, one thing I learned relatively early is you can't affect a persona that's not you. You have to be you.
Hallelujah.
And I would take all the courses by different style lawyers,
Right.
the colorful
over the top.
one, very florid, and it works for them.
Right.
And then you hear some of these good old boys down south lecturing, and maybe that plays down south, but I don't know whether it plays up here in the urban areas of New Jersey. So there are certain things you can learn that
Right.
you can use in your own way, but you can't say, I'm going to imitate F. Lee Bailey. I'm going to imitate, Jerry Spence
Right.
from Montana. And it takes a while
Right.
to mold yourself.
That's right.
You have to see who you are.
That's right.
And so you have to engage in some artificial mannerisms at first until you're really comfortable doing it.
Right.
And then you'll gel into who you are. I learned, it took me about 7 or 8 years to learn that you don't want oratory.
Right.
At first I used to imagine that every word I was taking down, was being taken down.
Right.
And it was. And I wanted to read it back and have it sound like Winston Churchill or somebody
Right.
like that.
Right.
But then you realize the jury wants authenticity.
Yes.
They want you, and they want you to be you. And, you've heard the expression, you can't fake sincerity, or you have to work to fake sincerity. But you really can't be somebody who you're not.
No. So you have to find your own voice.
You have to find your own voice, and it takes a while to get comfortable, because first, when you're first trying cases, you're nervous about trying cases and things like that. Only when you're comfortable in a courtroom can you begin to experiment and be yourself and talk to a jury the way you want to. But it's good to read all these books about trial manuals about good techniques to use.
Right.
But you have to do it in your own voice and with your own persona.
You kind of bring your own background to whoever that voice is, or your personal experiences. Obviously, there's something about you that makes your voice. You can't disconnect your own life and your own experiences from that voice, or do you think you can? Some people can detach, but you think as a good trial lawyer, should you bring in some of your own, I'm not going to say baggage, but some of your own background? Could it help you in a trial or something like that?
Yeah, I think so. I think the jury wants to see that you're authentic, that you're not, necessarily eloquent, that you can,
Right.
be who you are. And I try as close as I can. People say, who do you want on your jury? And of course, the nature of the case you're prosecuting, the nature of the client you represent affects that. But to the maximum extent possible, you can't always guarantee it because there's challenges on both sides. I would like people on the jury who I feel I can identify with, I can go out and have lunch with, or something like that.
And then my understanding is you worked as a public defender at one point.
I did that for 2 years.
Tell me about that experience. What was that like?
That was really, really exciting. I clerked for the judge for a year, and then I did my active duty, my 6 months active duty in the Army Reserves.
Okay.
And then I came back, and I wanted to get trial experience as quickly as possible. So I worked for a defense firm at the time that was defending automobile litigation. And, of course, when you first start, they give you cases in the special civil part, which were of little consequence, $5,000 upper limit. And then the public defender's office was just starting as a result of Gideon v. Wainwright, which was decided in 1963. But between 63 and 67, when a public defender's office opened,
Right.
they still would recruit lawyers to defend people. Now, Gideon
Right.
established a right to trial representation by everyone facing a felony charge or potential jail term. So they institutionalized it. They started the Office of the Public Defender. And I was there on the day it opened. And the people, there was the appellate section, different counties, and we were all young. I'd like to say the best and the brightest, but they're really exciting. Some people I went to law school, some other people. And I couldn't believe I had this responsibility. I was 26 years old, representing people. And nobody in my family was a lawyer. No, and I was like a professional, and it was so exciting. And I couldn't believe that this was not a game, that I was doing it for real. I tried 4 murder cases, got acquittals in every one, which was absolutely, unbelievable. And I did some appellate work for the PD. I did some trial work for the PD. I argued before the appellate division regularly, argued before the Supreme Court a number of times. And it was just so exciting. And we were all, not all of us, most of us were single at the time. And I just couldn't believe I was doing this stuff. And it was just so daunting. And after a while, after about 2 years, it gets to be a little repetitive.
Right.
But what was good in the public defender's office when it first started, it was not a full-time job. It's what they called a prime-time job. So the public defender's office allowed you to work pretty undefined as a prime-time job, definition, 60% of your time. So if you wanted to build a practice, you could. The only prohibition was you could not handle a criminal or a quasi-criminal case. You couldn't go to municipal court.
Right.
You couldn't go to. So some people were opening their offices. Some people were already experienced when they went to work for the PD's office, and it augmented their salary, and it was great.
So you got your confidence as a public defender. You liked it. You were very good at it. At what point did you go into civil litigation and personal injury or product liabilities? At what point in your career did you go into the civil litigation side?
I had met a public defender in Morris County. His name was Lou Stein. He was a very good lawyer, and he was about 6 or 7 years older than me.
Right.
And he already had a practice that was his practice, but he was also at the public defender's office, so he wasn't just building it from the day.
Right.
And he was looking for somebody, and it's always a big thing when you look for your first associate. And my boss at the public defender's office recommended me.
Right.
So I met with Lou. His office was out in Netcong, and we had a great rapport. I went to municipal court with him that night and everything, and he offered me a job. He said, you'll work two and a half days a week, and it sounded great. And then I was enthusiastic. I just got married, and then I took my wife up to Netcong. And it was a little too rural for our taste. So I called Lou, and I said, sorry, but no thanks. Within a half an hour, I get a call from a law school classmate of his who had gone to NYU Law School with him, who was 10 years older than me, and he and another fellow he knew had just started a two-person firm.
Right.
And one of them was an office lawyer, did transactional stuff, wills, corporations, represented the town of Springfield. And the other fellow named Sherwin Drobner was a trial lawyer. He did mainly personal injury, did some criminal. And he called me. Lou told him this, but he's more local. I got a job with, he interviewed me. He said, when can you start? And what's our arrangement? Because it's nervous for two guys who are new to hire an associate. So I said, I'm making $13,000 a year for the public defender. That's $50 a day, $250 a week.
Right.
So how about if I work for you for $50 a day, 2 days a week? And this began in October of 69. October of 69. And
good year.
Essentially I made myself indispensable by January of 70. So I went to work full time, and and I became a partner. It was a three-person partnership.
Did you enjoy doing personal injury, civil litigation?
Yeah, it was a very general practice. Sherwin kind of let me on my own. He had a people practice, and I'd go to court. None of the cases were big; they're pretty much all the same.
Right.
Trying cases. I did some matrimonial. I did some minor zoning if people wanted to expand their deck or something like that. I had a will contest or two. It's an interesting experience with Sherwin, who has long retired and moved on to other things from practice of law. He's 85 years old now. But I could tell stories about him. I don't know if Reader's Digest still has it. I hadn't read Reader's Digest in years. But he used to have a regular monthly column, the 5 most unforgettable people I ever met. And Sherwin Drobner would have been and still would be one of the most interesting people I ever met. It was an extraordinary experience with him.
What made him interesting?
Well, he was a very smart guy. His wife was a psychiatrist. And Sherwin kind of went against the grain. He was his own person, very interesting kind of guy. And a wide variety of people and contacts would come to him. His father-in-law was a doctor, would refer him patients. And he had a lot of moxie. I remember one case, and again, I'm so young and I'm so happy I'm doing stuff. I'm 27, 28 years old. We got a call one day.
Right.
We got a call one day from a woman. She had been a Catherine Dunham dancer. I don't know if you know what Catherine Dunham dancer? Yeah. It was a group of African American dancers, one more attractive than the other, all for whatever reason, I don't know why, light-skinned. And now she was beset by arthritis and rheumatism. She could hardly move. But in any event, she had been married to somebody.
Right.
They never got divorced. And it turns out that he was apparently, and she hadn't seen him in years, apparently a big drug dealer, drug trafficker, based in Baltimore and Atlantic City. He was killed by some Confederates.
Right.
She got our name from one of Sherwin's law school classmates and called us.
Right.
And Sherwin and I went, and whatever was his, and he had no will, was going to be hers. He left the sailboat. He left the yacht. He left a Corvette. He left in an apartment he had where where the polo grounds used to be, things like this. And I wound up driving a Corvette, and it was all just very, very exciting. The kind of things that happened there. It was just.
So this is all going on in your life. I mean, it seems like one thing after the other is going well. I mean,
Yeah.
did you have any disappointments earlier on in your career?
Not,
It seems like everything was cozy. Everything was just going.
I
Your
loved it.
enthusiasm seems like was triggering a lot of this. You seemed
Oh,
like you were
I-
just
I-
so into it. You were happy,
I loved it.
happy-go-lucky in a way. Like you just couldn't believe that you have all this responsibility. You're a professional.
Yeah.
As my understanding, it's like one of the first professionals in your family, right?
I was the only professional in my family.
What is that like? Is that any different, or does that matter? Does that take its toll? Do you have pressure on you to make it as a professional if you're the only one?
I don't think so. For me, it was good because already, you know, I was happy. I passed the bar and I was a lawyer. The only barometer I had was I had three cousins, three sisters who were older than me. The oldest one went to NYU Law School, and she married a professor named Bernard Schwartz. Bernard Schwartz was a brilliant guy. He wrote loads of books. He was very famous at NYU Law School.
Right.
And my cousin became my cousin Aileen, who was probably 15 years older than me, became a family court judge in New York. And Bernard Schwartz had very thick glasses, and he was very much like an academic kind of guy with not a big personality. So I was 3 months into law school in October of '66, and one of my younger cousins, once removed, was getting bar mitzvahed. And so I'm 3 months into law school, and Bern was always somebody who would come to the family, he'd be pointed to as the smart person in the family. So I'm 3 months into law school, and at the bar mitzvah, my father says, "Go talk law to Bern. Go talk law." And it was
Go talk
just
law to this law professor.
yeah. You know, but he was a
Heavyweight sounds like.
he was a heavyweight.
Academic
Had
heavyweight,
thick glasses. Wrote all of these books. Was counsel to some commission for a period of
Did
time.
you approach him? Did you talk law?
No, I'm embarrassed to talk. You know, what am I going to say? What about Mapfield, Ohio?
Was your family Matthew? Was your family proud of you? Did they express that? Like, hey, look, you know, you're going in the right direction. You're doing well. I mean, did they ever express that, or they were a non-expressive type family? You get both. But they say, look, we're proud of you, Ken. You're doing a great job. Did you ever get that kind of discussion? Or not really?
No, this could open up a whole psychiatric can
I
of
don't
worms.
want to, but
No, that's okay. My parents, I'm sure, were loving parents, but they weren't warm and cuddly. They were with one another,
Right.
But you know, they weren't huggers or kissers or complimenters. If I came home with all A's and one B, my mother would say,
look at the B.
"Look at the B." You know.
That's not necessarily a bad thing. So
No. But no,
yeah.
they
You don't necessarily get a pat on the back every single time you did something where you might have, it was your obligation to do so or something like that. It sounds like they didn't want to. I don't know. I mean, I'm not being a psychiatrist here, but because I think sometimes lawyers, doctors, accountants, architects, the professionals, they go into it because they love it. They're very good
Yeah.
at what they do, but they also want to get that affection, you know, from family, like the pat on the back. But it sounds like you didn't get the pat on the back.
No, I really didn't get. I really didn't get the pat. My father died when I was. Let's see, my father died in 1973. My father, I guess I was 51. I don't think I was 31. My father never saw me really become successful. You know, he saw I was a law clerk. He came to that Hurricane Carter trial that I was involved in. Was excited about that, and I'm sure they were very proud that I became a lawyer. My brother became a doctor. But I'm sure they were proud
Yes.
because they measured success by what other people thought.
Okay.
Okay? So they had friends whose children maybe did not become professionals.
Right.
And they wouldn't say anything, but I knew, well, their friends may have had more money than them, that it gave them a certain sense of satisfaction
There you go.
that their children did not shoplift,
Right.
their children did not use drugs, and nothing ever happened that was embarrassing to them, to their children.
And we're talking about the late 60s, early 70s, where America was a different place. America was a different place.
America was a totally different place.
It's probably a great time to be a professional, I would think.
It was
There's
great.
a cultural revolution going on. There's a lot of things that were good. The 50s have been overcome. Then you had the beatniks, then you had the hippies and so forth. How do you practice law in that culture? Was it different for you? I mean, did you have people with long hair, or they were more conservative as far as?
So I was kind of caught in a warp. I missed. I graduated college in '63.
Right.
I graduated law school in '66. Marijuana, you'd hear a little about when I was getting out of college, a little more about in '66, but everything changed in '69. That seemed to be the year that everything changed in '69. It was right after the Chicago Convention or before the Chicago Convention. It was Vietnam was really heating up. Woodstock was taking place. The sexual revolution had taken place, and everything. And I was just newly married, right. So I kind of missed that. Right. So I was caught between two generations. But it was very exciting in those days. The practice of law was totally different.
Please tell us, because people complain to me. They love law. They love everything, the colleagues, the friendship, meeting them after a drink for a while, talk about war stories and stuff. That's all still goes on, and it's very healthy.
I love talking war stories with lawyers.
And I think it's wonderful. It should go on more often.
It should, yeah.
But what I was told by some of my mentors and senior people in my life, that there was a little more of a cordiality. People were much more cordial with each other, even though if they were on the other side of the aisle. You say you have an adversary. Let's say you have some personal injury lawyer, then you have an insurance defense lawyer. Your word was your bond, in a sense. I'm not saying that's necessarily the case now, but now everybody does memorialize everything. So was there a little bit of, or is that a myth? Were lawyers friendlier to each other and more, or is that just nostalgic but false?
It was a much smaller community.
Okay.
Much smaller, much less anonymous community. Now, I don't know the exact numbers, and I'm just going to estimate or spitball numbers. When I was sworn into the bar, you literally had to be sworn in and sign your name to the roll. So years ago when somebody was disbarred, they'd say, so-and-so is disbarred and his name is ordered stricken from the roll. And that was literally. So I think if there were 8,000 lawyers in the state when I was admitted in '66, there are over 100,000 lawyers now.
Right.
And I recently saw in the annual survey in the Jersey Law Journal what percentage of lawyers have been practicing 50 years or more. And it's like 1.2% or something like that. But it was much less anonymous. Right. You knew one another. Everything was different. I mean, even certain things in a law, for example. Let me talk about office processing, first of all.
Right.
Nobody knows under the age of 50 what carbon paper was.
Right.
You know what carbon paper is?
I do.
Oh, you know what carbon paper is. You're a savvy guy.
Mimeograph,
yeah.
Carbon paper. But I knew if you made a mistake, like they had typewriters. We're talking.
They had typewriters, yes.
If you made a mistake on a page, you'd have to go back and rewrite the page. Is that correct or no? Or is there? It was just much more difficult.
My understanding is
Right.
if there was a will,
Right.
particularly in those days, the will had to be perfect.
Right.
There was no whiteout,
No.
erasures. So you needed highly trained secretaries, which is a word that's disappeared from the lexicon,
That's right.
by the way.
That's right.
Everybody's an assistant or an executive assistant. But there was no room for changes, and there was no electronic word processing or anything like that. So if you had to make 3 or 4 copies of something, you'd put the main piece of paper there,
Right.
then a piece of carbon paper, and then another piece of paper that was onion skin paper,
Right.
and then another piece, and it would just come out where the first copy was black ink and the rest looked all blue.
Right.
And it was very primitive, but it seemed that that's the way it was.
That's the way it was.
And there were no fax machines. Telephones that have a plug. If somebody called, Mr. Javerbaum,
Right.
it's for you. And then they take the plug out and put it in another cylinder. And then instead of buzzing you on an intercom, they'd yell, Can, line two.
Line two.
Line two. There were no laser printers. There were no fax machines. Everything was totally, totally different. Lawyers, when they closed the title, they'd go bring the papers to the Register of Deeds and Mortgages. All pleadings needed backers on them, which are kind of formal blue things like that. And courts had different hours. Courts used to open at 10. You'd go for lunch between 1 and 2 and come back for 2 more hours. There were 5 hours a day. Then later they moved it to 9:30, and now they moved it to 9. And when you went to court at 10 o'clock, most of the lawyers' offices were near the courthouses. So the assumption was a lawyer, even on trial, get to his office early, leave his office at 9:30, and go to trial. And in the big firms, you were expected to wear a hat when you went to court. I have a friend who I'm still friendly with. He went to work for a big firm. After 2 or 3 years, a big firm in those days was 13 people, 14 people. They were in downtown Newark. And after 2 or 3 years, he was finally was told, tomorrow, one of the senior partners said, you're going to court with me. You'll be second chair. Make sure you show up so we can go to court together. And he was there. He was looking forward to it. And he took his attaché case, and he went to take the partner's attaché case. And the partner said to him, so-and-so, you ready to go? Yes. But where's your hat? I don't have a hat. He says, well, you can't go to court without a hat. It was just very, very
formality.
different.
I like it.
Oh.
But here's a question. Because this is, I think, there's a lot of breaks in law, the evolution of law. The civil certification came in, it was in the early 30s or 83 or something, where you're a certified civil trial attorney.
82.
82. Now, before that, a lawyer would do a closing, a lawyer would do a divorce, they'd do a personal injury case, they'd probably do a will, whether it's a small firm or solo practice for that matter. How did that change the practice as far as you know, when it becomes specialized in a sense? You're a certified civil trial lawyer. What does that mean?
Well, it was certainly good for the practice that I started with my partner in 1978. And you're right. Before that, if you were a lawyer and you were a solo, you were a lawyer. And in those days, you couldn't get referral fees. It was illegal to get a referral fee. So there's no motivation for you to refer a case to somebody who you knew to be a good trial lawyer. So if your next door neighbor got involved in an automobile accident, you became his lawyer. That kind of thing. But certification began as a result, from what I recall, Warren Burger was Chief Justice at the time, noticed, and I guess he got other information from surveys, that the trial bar was very inconsistent. A lot of people were trying cases who really didn't know how to do it. So New Jersey, I think, was the first in the country, or one of the first in the countries, to start the certification process. And it was very arduous at first. You had to fill out this application that was overwhelmingly difficult. It was multi-page. You had to list, I don't know how many cases. You had to have at least 50 jury verdicts or something like this. You had to give references, at least 1 or 2 of whom were judges before you had tried cases. And if your application was approved, and again, it was daunting to approve it, if it was approved, you then had to take a 6-hour test, and pass it. And even now, from what I read, there's only less than 2% of the lawyers are certified civil trial attorneys. But the benefit was to the public and to lawyers. If you were a civil trial attorney, other attorneys would be motivated to send their cases to you, knowing you could probably get a better recovery than them, and you were allowed to pay them a percentage of the fee. So that was a motivating factor that led Jack and I to get certified. And for the public, it's good because they know the lawyer they're getting, if they're referred, is somebody who's comfortable in court with the rules of evidence, with how to pick a jury, with things like that.
So to highly complex cases, you didn't have necessarily someone that does a little bit of a general practice. It was referred over to a certified civil trial attorney that could probably analyze it better and handle the case and be prepared for trial. Is that the idea behind it?
That was the idea behind it. Also, the defense bar knew the competency of the lawyer as opposed to somebody else who's just trying an occasional case.
Right.
Also, with cases that were referred, very often they involved laying out money because in most of those personal injury cases that require development, investigation, the expenses can be very high.
That's absolutely.
And you're not going to ask your client to lay it out because they probably can't. And if you run the risk of getting no recovery, you're not going to get money back from your client either. So you had to deal with lawyers who were experienced, willing to take the risk. And, again, the motivation to the referring lawyer would be they would get a percentage of it. Now, I should tell you, before they became certified,
Right.
it was honored in a breach very often because you could only get a referral fee if you sent the case over to the extent that you participated in the work effort, and you get a fee in a proportion equal to your work percentage.
Right.
So more commonly, the lawyer would refer it over,
Right.
would not do anything,
Right.
and then the lawyer who resolved the case would thank the referring lawyer for their invaluable assistance during the course of the case, which was all a ruse. We did not. That was before our time, but that's the way it apparently worked in those days.
And it did help out the growth of your firm, I think, correct?
I think it did because we were among the first people to get certified, and it gives you, because the percentage of people get certified is low, and you have to be able to know how to monetize that if you're certified. You don't want to hide your brilliance under a bushel basket, so you have to know how to use it, promote it, get involved in bar dinners, let people know you're certified, and it's not just getting certified; it's being opportunistic about it.
Absolutely. I mean, that makes sense because I find the best cases that I get referred to are fellow attorneys that don't do your area of practice.
That's right.
Because I think for three reasons. One, you don't want to let them down. Two, it's a valued client to them and they trust you by sending it to you.
Sure.
And three, if you do a good job and then the client calls them and says, listen, that was a good referral, thank you, you'll probably get more repeat business from that lawyer. I think lawyers are great for referrals of cases.
I think lawyers are very often, depending on the nature of practice and the nature of how you handle it, less your competition than your cohorts. You can get a lot of, and then there's something else I started, and I did it with two people, and I spread the word. Somebody had sent me a referral.
Right.
Either while that case was pending or after that case was over, the referral then called me directly to send another person. So I called the original referring attorney and said, you sent Mr. A to me. I just want you to know Mr. A referred Mr. B.
Right.
I can send them back to you, but if you want me to handle it,
Right.
I'll send you a referral. And he was flabbergasted that I would do this kind of thing.
Right.
But he let the word out. And
Yeah.
if you're going to be
That's honorable, very honorable.
well, it's not only honorable,
It's the right thing to do.
it's the right thing.
Yes.
It's not only honorable and the right thing
The
to do.
genesis is that
It's
lawyer.
the short-sighted thing not to do.
Absolutely.
It's
I
the
agree.
short-sighted thing not to do.
Lawyers are called a lot of things, but they're very smart and they also respect loyalty and fidelity.
Well, not all of them.
Right.
I know some lawyers who accept referral fees and then kind of welch, if that's still a word.
They won't get any more referrals. That's the whole thing.
No, we had a case 3 or 4 years ago
Right.
where a lawyer sent us a case.
Right.
Nothing was in writing assuring our acknowledgement of his sending us the case. Nothing acknowledging that when the case was over, we're going to send him a third, which is customary. And we sent that lawyer a referral fee of over $1 million. He did nothing. He sent the client to us. He did nothing. But he let the word out. Can you imagine that?
I can. And I think he let the word out. I mean, that's it. I mean, that's like a flowering effect.
Yeah.
One lawyer usually knows 20 other lawyers. And if they speak highly about you to 20 other lawyers,
Yeah.
that could be 100 cases, perhaps. I don't know.
What we started doing, I had spoken, he was interested in establishing a relationship with us. He was a lawyer in Newburgh, New York,
Okay.
and his last name was Finkelstein.
Okay.
He invited me to his office in Newburgh,
Right.
which he self-characterized as the armpit of New York. And this was circa, I don't know, the early 80s. And he had already started marketing because of Bates v. Arizona, which allowed lawyers to market. And he had this computer, which now is probably less filled with information than your iPhone.
That's right.
But it's a huge room with all of these things,
Right.
all of these computers. And he had all of central New York. He had offices in Albany and Binghamton and Newburgh and even up to Buffalo.
He's
things
covering
like that.
the upstate.
He is now subsequently, because I read he's being sued the other day, he became Jacoby and Myers. Jacoby and Myers went bankrupt, and he took over Jacoby and Myers' practice. Oh, but the point I was going to make about him, Howard Finkelson, he made a good point. He would pay referral fees. And he said, when you pay a referral fee, and I remember he was pretty good about it, he said, you never send it to him. You call Charlie,
Right.
and you say, Charlie, let's go for lunch. You're free next Tuesday. And you go with an envelope, with the referral fee, and you say, I'm sure you got in your drawers, Charlie, a couple of cases you're holding on to.
Right.
You think you can probably settle them on your own. Why don't you just let me have those two, and I'll take care of those kind of things. It's a very good
Absolutely.
idea.
It's a very good idea. It's,
Very
it's a
good
win-win
idea.
situation. It really is. I mean,
Yeah.
it's absolutely a win-win situation. So now we're going into the 80s. What was the law practice in the 80s? Because I've heard certain things. Some people say it was a heyday for personal injury. It was great times. Was it as good as they say it was, the 80s?
Well, from the time I started practicing in 66
Right.
until the 80s, and even now continuing, I think particularly in New Jersey, and particularly in the area of personal injury, products liability, medical malpractice, and those kind of traditionally contingent fee things, the law has been very progressive and very good for claimants.
Yes.
And the 80s were, I think, just before no fault started in various incarnations. And it was very good. There were no thresholds.
Right.
And the law started at the lobbying instigation of the insurance companies, where to reduce insurance company costs allegedly, they began putting certain limitations and caps to satisfy to have, lawsuits, unless you had a certain injury of a certain degree. And they've changed it over
Right.
the years,
Right.
really changed it. But when I first started practicing for 25 years into the 80s, there was no cap. You could have, very little, and the case would have some value. And the 80s were, I don't remember exactly the demarcation of lines and decades, but the 80s were good because every case had some value. Now, when I first started practicing, there was no such thing as comparative negligence. There's what they call contributory negligence
Oh, boy.
until 1972. So if you were walking and there was a terrible defect in a property,
Right.
you might not get any money because even though the landlord or the owner of the property was 90% responsible for this terrible condition, 10%, you should have seen it. So you
Right.
got nothing. The jury was not asked to assess comparative negligence.
Watch where you're going, defense.
Yeah, or the helicopter defense, where it came out of nowhere. But that was a killer, and then they eliminated.
It's
And it was
so unfair. It's very unfair.
And then they had until 72 or 73 interspousal, interfamily immunity. So if you were driving with your spouse or your child in a car, you could not.
No.
You could not sue, and that was a real limitation on things. And then in the 80s, products liability, which really began in New Jersey,
Right.
the early days were the 60s, and then products liability began to take hold and became really New Jersey was at the front end of the progressive products liability with the Weintraub Court and Francis, and they had giants in products liability, a much more progressive court than we had now. They became a great source of business. Medical malpractice cases
Right.
were rare when I started because there were only 2 doctors who would testify. And there was, the code of silence or
Of course.
something. And but the 80s were really terrific.
Is there any case that you remember that put you on a threshold where, yeah, I've arrived. I've settled a big case, or I tried a big case, and this is the one that I could go home and not necessarily brag about, but be, because you're taking care of your client, you're getting the best result for your client. Is there any case or cases that come to mind that just said, this is it?
Well, there were a few. I can tell you this. The first $1 million verdict the firm got was after we were certified. The client came to me, but my partner Jack Wargaft wound up handling the case. I still remember the case. I still remember the name of the case, which doesn't matter. But it was a person, a Spanish-speaking person, working underneath a car to repair the car. And he had one of these lights that looks like a fluorescent light. I forget what they call it.
Right.
It was designed to illuminate, but they did not tell you that it generated heat and it burned. And it was marketed in a way that you'd use it under a car when they didn't, warn you about it,
Right.
and they could have given you one that did not generate heat. And Jack tried that case and got over $1 million verdict in the summer of 1984.
That's big money.
That's big money, particularly in 1984. And then I had a case. I'd settled a lot of cases for $1 million, but a big one was in 1990. I worked hard on a case. Settled it for $10.6 million. Had to go to Peoria a number of times because that's where Caterpillar was located. Very interesting case. And I remember it made the Law Journal. It was a big article in the Law Journal.
Did that do with backhoe at all or something?
Yes, it did. It was a Caterpillar backhoe. And I was in Morris County within the next week, and a guy who I knew said, "Hey, congratulations, Ken." And I had never heard this expression before. You now have your FU money. I remember this guy saying that.
That's a good. I'm glad you raised that. So, okay, people know it's in the New Jersey Law Journal. You had a $10 million case. You walk around the courthouse. Do they look at you differently, or is that the same old Ken, or now Ken is on a different stratosphere at this point? Sorry, I know I'm not asking you to brag or self-promote.
No. I was doing well with cases before that. We had a lot of big cases, and I knew what I was comfortable doing that. That may have been the equivalent of the official laying on of the crown, if you will. That's
the coronation.
That might be like the coronation. All of a sudden, we have something like that. Yeah.
Well, you said you worked hard on it, and
I worked very hard on it. I had over $120,000 in a case, and it could have been a no cause.
That's right. So, and also the clients. You remember the first meeting with the clients, and
Yes.
they look at you.
It was referred by another lawyer. That
Right,
case.
and they look at you and they say, "Can this guy do the job for me?" And then you come through for them, and it's very fulfilling, I think, for both sides, the lawyer and the client, in my opinion.
I think it is. These clients were not very sophisticated. He was a Portuguese-speaking construction worker. The accident caused him loss of both of his legs and his pelvis, and it was just a terrible situation.
So sad.
But that case had something that other cases have, and it's palpable. If you're tenacious enough, do enough investigation, enough discovery, there can come a time when somebody says something at a deposition, and that's it. I have
The light bulb goes up.
The light bulb goes off. I have the theme of my case. That's it.
That's the theme.
And I remember what happened in that case. The defendant was always perceived as the case went along. Had a whole same group of nice defendants, or four or five defendants,
Right.
and we'd all fly. I'd pay. We'd go to Peoria because Caterpillar was hiding their witnesses. We'd go either via Chicago or via St. Louis. I'd buy people dinner. We all got along real well. And the heavy defendant was perceived to be Caterpillar.
Right.
But then I saw that asleep at the switch almost was this construction site manager
Right.
on a job and what they were supposed to do and how they could have avoided the accident. And so I was taking a deposition in Philadelphia of a guy. He was a named partner in a construction management company. It's called O'Brien Kreitzberg.
Right.
And his position was that construction management responsibilities did not include safety. It included making sure the job was done right,
Right.
making sure the job was done on schedule, making sure the job was done according to the estimates, and had no safety responsibility.
None.
And then I pulled out the book that he had written,
Touche.
and he had forgotten about the book.
Let me guess. They said safety is one of the requirements.
Oh, he had a whole nothing is more important than safety. Nothing is more primary than safety. I'm not sure how I did it, but I enjoyed doing it. I may have said to him, would you agree with the following statement without showing, I don't recall.
Do you know who wrote that statement? You did.
Absolutely. And it is. There was another case I had, which was a highway defect case, which were very difficult to establish.
Yes, those are tough cases.
I really became an expert because I have an alter ego in my office. Somebody who doesn't get any credit, who's been with me for years, never goes to court, Tony Valenti. He knows more about Title 59, claims against governmental entities, than anybody in the state. And he's incredible in these Title 59 cases where we made our mark and get a lot of referrals. And I had the state's chief highway engineer on the job. And I was questioning about some highway repairs. And finally, he said the following, which became the theme of my summation. Remember, it's the state of New Jersey with God knows how many billions of dollars. Referring to this job, he said, it was a seat-of-the-pants job. Which words came back to haunt him. And every once in a while, there's a moment in a deposition where, you start counting your tuition bills that you paid.